Welcome, everybody. I'm glad everybody could make it. I see some familiar names here as part of the meeting. So this meeting is what we're referring to as just a towing stakeholder meeting, but really what we're going to be doing is going through kind of point by point the recently passed legislation, House Bill 24-1051. There are some new things that are going to be triggering in the statute a week from now on August 7th. So we wanted to just have this stakeholder meeting to kind of review what is going to be triggering in the new statutes, what it means, what the language is, the new requirements that are going to be start being imposed through those statutes, and then kind of, just kind of to have a discussion about, what changes this is going to have and what impact it's going to have on the towing industry starting next week. So the plan is to go ahead and just share. I'll be sharing the screen here in a moment with just a copy of that bill, the final signed version of it. And we're going to just go through the entire thing. And, feel free, everybody, to ask questions at any point. One thing I should mention is the chat has been disabled for this meeting. So please don't chat anything. We won't see it. If you want to ask a question or you have a comment, feel free to jump in at any point. I'll try to keep us on track for the most part, but I don't mind if we stop in certain places and kind of have small side conversations about some of these new requirements. If you plan to do that, please, the easiest way is just going to be to unmute yourself and go ahead and, say what your comment is, or if you have a question, you can just go ahead and ask it. You can raise your hand too, if you want. So if you're operating in the Zoom app, either on your desktop or through your phone, there should be an option to raise or lower your hand. I'll hear it, so I should be able to see you, and then I can call on you to say your comment if that's a cleaner way to do it. But I don't really mind if people just jump in as well if you have a question. If you're on the phone, you're not doing it through the Zoom app, either on your desktop or through your handheld. If you're actually on a call, there are some controls you can use within the phone. So if you want to toggle to mute or unmute yourself, you would use *6. And if you want to toggle or raise or lower your hand, that would be *9. So anybody who happens to be on an actual call, that's how you accomplish that. Otherwise, you should be using the app, and there should be just a button you could press to either raise your hand or unmute yourself. But for the most part, if you're not planning to speak, if you could just stay on mute, that would be appreciated. Just that way we don't get any background noise or anything. We can kind of stay on track. So we'll go ahead and just jump right in here. Let me go ahead and share my screen. Give me 1 second. Oh, and just as a reminder, we are streaming this. If you have the link, you can go ahead and obviously you all have the link who are in here. That's really the only way to get in. But you can also, if you're not planning to participate and speak, you can also watch it through our YouTube streaming channel on the PUC. It should be up there right now. I think there's about a 30-second delay, but that's really the only difference. And obviously you can raise your hand or speak or anything as well. Also, wait, hold on. Okay, let me get this up on the screen and then we'll go from there. Give me 1 second. Yeah, I'm going to be, just FYI, I'm going to be looking around. I got a big screen here and a lot of different windows I have open, so we can kind of get through this as smoothly as possible. So if I'm looking around, hopefully that's not distracting. If it is, I'll turn my camera off, but hopefully we can just get through it. All right, let me go ahead and get to the top here and share this. Okay. Okay, hopefully that is good and you all can see that. I'm going to go ahead and I'll zoom in just a little bit just so the text isn't, oh, that's too much. Okay, we'll keep it right there. If you find it's too small, maybe just say something and maybe we can twiddle with the settings for the font size and all that. But for now, we'll just keep it as this. So again, this is primarily a review of House Bill 24-1051. It did pass as part of the 2024 legislative session, and it looks like it will be triggering. So all the statutes we're about to go over here will become effective on August 7th. Just as a reminder, any statutes that would potentially conflict with current PUC rule will be essentially overridden. So if there is a conflict between one of these new statutes and current PUC rule, the statute prevails. So just be aware of that. So we plan to enforce these statutes starting next Wednesday on August 7th. So please adhere to those in that manner. So, but let's just go ahead and start going through them, and we'll talk about these different changes, what they mean, again, how we're going to be applying them. And again, if anybody has questions, feel free to jump in at any point. So we're going to go ahead and start with the new permit requirements under 4010.1401 here. So a few different things to talk about here. The PUC, based on these legislative changes, now have expanded authority to suspend or revoke towing carrier permits on the basis of felony convictions, towing related offenses, and other good cause criteria. Although technically they've gotten rid of that good cause reference, so it's actually just, I think we're referring to it now as a public interest standard. So basically what this means, it's essentially just an expansion of what they passed as part of the legislation 2 years ago. So in House Bill 22-1314, they essentially put a provision in there where the commission has the authority to deny a towing carrier permit if there was a determination of good cause why the carrier should not have a permit. It's not a standard we really admittedly used a whole lot, and it was really only in very significant situations that we were using it. So really only a handful of times that we've used it in this past 2 years. But basically, again, we still have the old disqualifiers for before, for felony convictions within the previous 5 years. They also added towing related offenses 2 years ago as well. I don't think we see that one as often. So usually if we have denials based on a disqualifier, it's usually due to the felony convictions or due to that, what was formerly known as the good cause standard, which again, now we're going to be referring to as the public interest standard. So one thing to keep in mind is the addition here, and I'll try to highlight this, hopefully you can see it. So them adding the words suspend and revoke to this statute basically expands it in a way where, so the way it currently works is if we have a pending application, whether it's a new application coming in for the first time or a renewal application of an existing permit, that's really the only time we could utilize the standards outlined in these statutes. Because there was reference to denying an application, so some kind of a pending application. The way we are reading this now, based on the inclusion of the term suspension or suspend and revoke, is that we can essentially apply this standard at any point. So I'll give you an example. Say we are, reviewing a particular applicant's towing permit, and we are aware that they have pending felony level charges. Now, of course, if that ends up resulting in a felony level conviction, that would be a disqualifier pursuant to the standard. However, if it happens 4 or 6 months after a permit has been issued, essentially what we were forced to do is wait until a new application or renewal application had been filed. This essentially would eliminate that and allow us to essentially intervene against a permit at any time using this exact same standard, but not having to wait until there was an actual pending application on the table. So that's essentially the difference here. So expanding upon that, and again, it changes it here, it changes it here, and then also down here as well under, again, what used to be known as the good cause standard, but as you can see, they deleted that language out. So now we're just referring to it as a public interest standard, as indicated there. So again, the felony convictions and the towing related offense convictions, those essentially can be applied at any time. Similarly, this public interest can also be applied at any time. But as I mentioned before, we're using it pretty sparingly. There's not a whole lot of times that we pursue that. So I wouldn't really expect that to change very much. It just gives the commission some additional flexibility that when we see something that's an issue that could potentially be a disqualifier, it just gives us the additional latitude to pursue it, at any time, not necessarily only when there's a pending application on the table. One other thing that they added here is a rebuttable presumption. So I highlighted it here. So the rebuttable presumption is basically what would be kind of the minimum threshold for a towing carrier getting a permit not being in the public interest? Like what would be that minimum standard? Now they went ahead and put it in as it's listed here. So it says it is rebuttably presumed that a towing carrier's possession of a permit is not in the public interest if the towing carrier has willfully and repeatedly failed to comply with this Article 10.1 or Part 18 or 21 of Article 4 of Title 42. So that's basically anything in these towing statutes that the PUC has oversight for, or the abandoned motor vehicle sale provisions in Title 42 under Department of Revenue. So if we're seeing a towing carrier that has that is willfully and repeatedly violating either our statutes or those specific DOR statutes, that would give us kind of a more solid foundation to stand on in regards to if we wanted to pursue a potential denial or disqualification. So again, we will incorporate this. The plan is to incorporate this into our current standard for towing permit denials. So we will likely see some modifications to Rule 6504 in that regard. But yeah, that's the first part of this bill that talks about people getting permits. One other thing to mention here real quick, up here, we kind of skipped over it just because I wanted us to kind of stay with that flow of those two topics. But I think this was always inferred by the PUC's processes, but now it's actually in statute. Towing carriers that apply for a permit or that applies to renew a current permit is required to disclose to the commission each person that is identified as a principal in accordance with the rules promulgated by the commission. So basically, that can be a lot of different people that are associated with your company. It could be a CEO, an owner, a director, a partner, a member, again, depending on how your business is organized. I think that's always kind of been inferred, and that's always been an expectation we've had here at the commission, that all of those parties, that have, that level of decision-making authority within the company would be disclosed and are attached to those applications. Now, it could be 2 people, it could be 5 people. It just depends on how your business is organized and kind of who has the authority to make those types of decisions within the business entity. So again, I think this is something we were always expecting towing permit applicants to do anyway, but now it's in statute. So we'll go ahead and make sure that we modify the language in our rule to accommodate that. I believe we did. I think we're trying to incorporate it into rule, I think it's 6503, if I recall, which is our permit application rule. Okay, so that's the first section of the bill. It's all about permit applications. Moving on to 4010.1403. So this is the statute that houses the towing task force, which is a 14-member group. Most of the positions are appointed by the governor, and essentially it's their responsibility to essentially make recommendations to the commission on maximum rates for non-consensual tows specifically. That's their primary duty, and it's a group and a membership that has been in effect since either 2014 or 2015, and a lot of the current structure for the tow rates that you find in Rule 6511, a lot of that was coming from towing task force recommendations. So FYI, they've had quite a bit of hand in the past in shaping how towing things or how towing rates are currently shaped within the regulations. There's not really a whole lot to talk about with the towing task force. Again, this is just for the towing task force themselves to deal with their legal counsel. So we won't talk too much about that, but just kind of on a bare bone level, certain members are going to be prohibited from voting on certain matters when there's a conflict of interest. That's essentially what it boils down to. So if you want to read on that some more yourself, feel free, but it doesn't have any direct ties to what we're talking about today. The other thing under the 403 statute is there's an annual towing report that the commission is required to submit to the legislature every year. And this has been the case since dating back in 2021 with the initial passing of House Bill 21-1283. They kind of restructured the task force, made some amendments to 403 statute, and included this new annual report. They beefed it up, that report a little bit up with House Bill 22-1314. It's a lot more in depth than it used to be when it was first introduced. The commission now essentially may put rules in place to require as a condition of permit issuance or renewal any information from towing carriers that would be necessary to complete that report. I think, just having personally drafted these reports over the last few years, I think we can glean most of the information we need for that report from our own internal records, but we may be exploring that a little bit. In addition, it also does indicate that the commission can also request and collect additional information as part of the permitting process. So this information can include a variety of things that are listed right here in the statute. But I'm guessing how the commission will likely put this into the rule will be, it would probably be set up in a way where when you apply, whether it's first time or coming in as a renewal application, and maybe we'll set it up some way where you submit it through like a Google form or something. We're not 100% on that yet, but when you apply for a permit, the commission would be gathering information related to your operation. So certain data points that may be collected, for example, could be, how many tow trucks you have, what your operating area are. So, maybe we'll do that by county, maybe we'll do that by zip code. And, it would just be, oh, I'm operating in, Larimer County and, maybe 2 or 3 adjacent counties, things like that. Or maybe zip code, like all the zip codes you operate in. Also, what types of tows you engage in. Obviously, your towing permits, when issued, allow you statewide authority to engage in whatever types of tows that you want. And the 3 primary categories are still consensual, non-consensual, and law enforcement ordered. Some of you maybe do 2 of those, or maybe some of you do all 3. So having that captured when you apply for your permit will help just us get a better picture of the towing industry, kind of where the business is, what volume or percentages in each of these categories of tows you're conducting. Maybe we'll ask for example, like the last 12 months worth for when you apply, the last full 12-month period, we may ask for that much. Pricing structure for different categories of tows. So for example, if you engage in consensual tows, you all know those prices aren't regulated. It's just whatever the market allows. But we could end up asking for that, where as part of this information submission, when you apply for your permit, we may ask you, if you're engaging in consensual towing, what are the prices that you're charging? What's the hook fee? Or if you charge for mileage, what is that? Things like that. So, these are all things that could end up being asked for once these new rules become effective. As you see in the statutes that are currently highlighted, we're going to have to promulgate rules before we can actually officially ask for this, is what it looks like. So I don't know that we'd see this kind of a request coming in prior to these rules that are going to be introduced shortly actually becoming effective, which, as you all know, can take some time to go through the rulemaking process. But once that's done, it is something that we would apply and start asking for. And the reason I kind of elaborate on this is because you might want to start thinking about tracking some of this information if you're not already. I hope you all are already, just as part of your business. But things like, how many tows you're doing annually and what types of tows you're doing. So if you're just a straight non-consensual towing carrier, that's easy. It's all your tows are consensual. So that's easier to determine. So maybe we would just ask you for a total count, and it would be 100% consensual. But especially if you're operating in a way where you're doing different types of tows, different categories of tows, you may want to consider to start tracking that, just because if we start asking for this and it's something that becomes a contingency for you to get your permit, you're going to want to be able to be ready and able to provide that information. So anyway, we should have some more information on exactly the kind of stuff we may be asking for when we introduce the rulemaking. We might have some more information on that. But just kind of start thinking about this, and you can read the statute and see the kind of stuff that's referenced here directly in the statutory language, and just maybe look at your business practices and see if you're even tracking this stuff presently. And if not, you may want to consider putting some things in place to start tracking it, just so that when this comes up and something gets put in rule where we're going to ask you for certain things, that you're not caught off guard. You've already kind of pre-planned to be asked that. So just wanted to throw that out there. Again, that likely will end up in our rule 6503, which again is our permit application rule for towing carriers. One other thing to keep in mind, there is a deadline here. You see here, September 1st, 2025. So whatever rules we put in place that capture, at the very least, this section, are going to have to be promulgated and effective by September 1, 2025, which, as you can tell, is just about a year away, a year and a month. So our plan is to get this rulemaking going as soon as we possibly can, obviously after the statute's trigger in a week, but we are planning to get that moving as soon as possible. Moving along, we're going to go ahead and move on to 4010.1405. Now, as I'm sure most of you know, the 405 statute is more specifically tailored towards residential PPIs. So there's not really a whole lot in 405 that's going to apply to commercial tows. There may be some flexibility in certain areas, which we're still currently exploring. But anyway, just wanted to throw that out there. So a lot of the stuff I'm going to mention in this 405 section is almost exclusively going to be applicable to residential PPIs only. So just wanted to preface this section by saying that. So one of the things, and this is actually a pretty big change that they made as part of the 405 statute. The 405 statute under section 3 talks about tow authorization, like how you can authorize your tows. So, and again, we're talking primarily about residential PPIs here. So they essentially adjusted some of the language where in some places, I think it doesn't do much more than clarify what I think we had already all come to expect within the space of authorization. But it definitely zones in on a few things that we want to make sure we're adhering to. So essentially, starting a week when these statutes trigger, a towing carrier engaging in private property impounds is going to have documented permission of the authorization. So it can't be automated or pre-approved. And I think we've had a rule regarding pre-approval on tow authorizations for a long time. I think it's in 6508 B somewhere. It might be B4. Each tow has to be individually authorized, so you can't like batch authorizations together. Again, this is stuff that I don't know that we see a whole lot of anyway, but it will now be statutorily restricted. It still requires the 24 hours immediately preceding the tow for authorization. So, for example, you couldn't get an authorization 48 hours ago and then go tow the vehicle. That would be expired. It has to be within the immediate 24 hours prior to the tow. But then one of the big things they changed here is right here. So the documented permission for the authorization has to be through a form that was created, that is being created by the PUC. So essentially how we've interpreted this is essentially going to become a uniform authorization standard. We've gone ahead and finalized the form. And hold on, if you want, I can go ahead and show you what it looks like. Hold on, let me stop sharing this and we'll go ahead and share the form just so y'all can see it.
Hey, Nate, I don't see the raised hand. This is Steven from Elite Towing.
Yes, sir.
Hey, on this, we started using this authorization form. We had one question on it because it says, be filled out in full, and It has the vehicle make model. It has a spot for the VIN and plate number. Sarah had a question. We've ran into, what about when these people are filling this form out and the VIN is completely covered and it doesn't have plates? Can we
Right.
put like, not applicable, and is that fine, or covered? Maybe write covered, no plates.
Yeah. So I think that's reasonable. And again, obviously, there are going to be outlier situations where maybe not everything on here is going to be available. I think as long as you're doing your due diligence and you're essentially putting everything that's on here and maybe making a note or some kind of annotation that a particular data point is unavailable for some reason, I would imagine that will probably be sufficient. Obviously, we're going to address those on a case-by-case basis. But I think for the most part, as long as you are making a good faith effort to fully comply and fill these forms out as accurately and as completely as possible, I'm guessing we won't have too many big issues with that. So anyway, the form here, and again, we've made some adjustments to it. This is actually something we were considering putting in place over a year ago. But it's we were kind of back and forth on if we wanted to actually do it, because we realized that there's a lot of different authorization standards that towing carriers use that in some cases they've gotten used to. But again, now due to this new statute, we essentially have to put something uniform in place. This is just the way it has to be now. So as you can see from the form, we're referring to it as a property owner tow authorization form. You can see on the top, it has our logo at the top. And if you scroll all the way to the bottom, you can see it has our footer, it has the state seal. It's got some small print here. This is our standard PUC language regarding the consumer affairs number, just in case somebody has a copy of this and has an issue with it. There's that number. That's something the director has insisted go on a lot of our different towing forms. And also the date that it's been updated, so you can see today's date there, because we were working on this earlier today. So going back up to the top, you can see that it's all the basic information you would expect to see in a tow authorization. So you got your tow information here. So you got the date of the tow, obviously, the time of the tow, and also the property address of the tow, so where you're towing it from. Moving on to vehicle information, we added some additional things here. So again, we just want it to be as fully captured as possible. So a lot of this stuff is similar to what you might see on the tow invoice, for example. So make, obviously, the model, the color, the license plate, and the state. So it could be, 879-YUP, and then in parentheses like CO or NY or LA or whatever it is. And then obviously the VIN. Like you said, Mr. Carnes, some of this stuff might not be available. It might not have a plate. It might not have a VIN. And if that's the case, you do the best you can. Maybe write a note in there like not available or VIN scratched off, something like that. Pictures help too. Especially if we see one of these forms and something's not filled out, but you're able to readily show us, oh yeah, here's a picture of the VIN. You can see it's totally scratched off, or for whatever reason it was missing, it wasn't there. Whatever the situation is, that's definitely gonna play a lot better when we're having these conversations. So I would encourage everybody to take pictures of that kind of stuff when you're seeing it. Yeah, Ms. Bryan.
What about Nate? Like when we send, like, this is what we've been doing, trying to get property managers and owners used to this. We've been sending this form via email saying, hey, fill it out per car, and they send it back. So like the date and time, they're probably putting the time they're filling it out, not necessarily the time the vehicle is being towed. And then, yeah, they fill out the vehicle make model the best they can. But then obviously when we tow the car, we got to verify the VIN. So if the VIN's covered.
Yeah. No, I understand that. And what I would say to that is, yeah, this I think indicates when this authorization is being done. So for example, if it's, say, imagine a scenario where it's a residential PPI and it's not one of the exemptions for the 24-hour notice standard. So you got to do the 24-hour written notice. So in that situation, since the mechanism in the statute exists where you can actually have the authorization provided as much as 24 hours before the tow, you could potentially have a situation where the property owner or whomever the appropriate party is filling out this authorization at a time that's 24 hours prior to when you're actually going to tow the vehicle. And we'll see that distinction between what's on the tow authorization under this field here at the top under time and date versus what's on your tow invoice of when you actually towed the vehicle. And I think we should be able to make that distinction.
Right.
So yeah, I agree that, you know, the time that they list here may not necessarily be the time of the tow. It's the time they're requesting the tow.
Right.
So because again, it's the authorization and they're essentially providing you with the authorization to complete the tow. But again, it may be a situation where you can't tow it immediately. Or maybe it is. Maybe it's still a residential tow, but one of the exemptions apply. Maybe it's parked in a handicap space and it doesn't have the proper plating or placarding. So in those situations, when they're putting here on the time of the tow authorization, maybe only minutes from what is listed on your tow invoice is when you hook the vehicle. Does that make
Right.
sense?
Mhm.
Okay, cool. Ms. Bryant.
I just know there might be some times where it could be, they send this, abandoned car, they said this thing's been here for 8 months, we're here till 10 p.m., get here whenever. And they emailed us out and, we're just catching up. And, obviously we take those abandoned calls in priority. So, it could be an hour, 2 hours, or, maybe the property's an hour and a half away. So yeah, just as long as there's a little flexibility there, I just wanted some clarity.
Yeah, and I think this is more about when the authorization is being completed, because again, the tow invoice itself will list or should list exactly when the tow is actually happening. So,
Right.
and I think we understand there could be a discrepancy there depending on what the situation is.
Okay, perfect.
So, sorry, Miss Bryant, go ahead.
Okay. Yeah, that was one of my questions. But I was thinking that maybe if they could include a photo in addition to the authorization form, just so we're sure that we're getting the right vehicle, if that would be helpful. With our dispatcher sending this out for a few weeks, Lloyd had sent us a very rough draft of this authorization form. And one thing that they had mentioned was adding model and color as well, but also the violation. Is that something that you guys would be willing to do?
Okay, I see what you mean. So essentially putting somewhere on this form what the parking violation is.
Yeah, they said that would be really helpful for them when
Okay.
they get the authorization forms back, just so they know what the vehicle's being towed for.
Okay. Yeah, I get that. Lloyd, are you on?
I am, Nate. Go ahead.
How do you feel about that? I know,
No,
so
that's a good point because it's going to match up with the invoice for the tow anyway. So I think it's fine.
okay. Fair enough. Let me go ahead and plug that in right now as we're talking here. So it would be something like I think in the rules and the statutes, I think they refer to it as inappropriate parking. Do you think that's going to be too confusing? I'm trying to be consistent with our language here.
Like maybe inappropriate parking reason.
Or maybe reason for tow.
That looks good.
Maybe something like that. Okay. And then we can make that a nice long field. So we can give you the whole page for that. Okay. Yeah, I like it. Let me actually, you know what? Let's do this. Since let's put it up here.
And when will this form be available?
As soon as we can get it out there. And that's one of the reasons we wanted to have it as ready as possible today, like right now for this meeting, is because so we could show it to y'all and get exactly this kind of feedback. So yeah, no, this is good. Let me just resize this. Sorry, trying to be consistent here. Okay. Okay. So that should be good. Hold on, let me just put a space there. There we go. Oh, a few more lines there. Okay, cool. And then we'll get rid of this. And hopefully that'll, it's bleeding a little onto a second page, but I can fix that. Thank you, Ms. Bryan. I really appreciate that feedback. That's good feedback to provide. I appreciate that. Yeah. Okay, and then I thought I saw another hand raised. So if you want to jump in, feel free. Otherwise, we'll just keep reviewing this sheet. Yeah.
Heather Schlegel, I'm showing as J.R. Schlegel on the board right now. I raised my hand.
Yes, go ahead.
2 quick questions. Are you wanting us to use this when we're impounding vehicles from commercial properties as well? So are we using this across the board?
So I'm glad you brought that up. again, our intent, and again, we're going to have to do this a little more thoroughly through the rulemaking process, but the way I think we're intending to put this out there is that this is something everybody should be using. And again, it's actually to your benefit to use it as well, because we're structuring this in a way where if this form is used for your authorization, whether it's residential or commercial, if this form is used and it is accurately and completely filled out to the greatest extent possible, I think that would put you in the best position to make sure you never have another authorization issue, if that's something that's happened for you in the past. Because
Understood.
again, yeah. So what I would say is, yes, this is something all towing carriers should be using for any kind of a non-consensual tow. This is what I would use for your authorization. Absolutely. So, and again, it's going to be put in by statute anyway. But again, one thing I know we've been aware of is, especially based on what we saw in House Bill 22-1314, I'm sure you're all aware, we had to kind of take some of our regulations that had been more, I guess, uniformly applied to all types of non-consensual tows. And we had to kind of split them up in certain sections where it's like, oh, for a residential, you do this, for a commercial, you do this. I think to the greatest extent that we can, we're trying to avoid doing that. We're trying to keep things still as consistent as possible, for the simplicity for all of you, for the consumers, for us. Where we can, we're trying to do that. And I think we saw that a bit in our last towing rulemaking, and we couldn't get it to work everywhere. But I think to the greatest extent that we could legally, we put certain standards in a way that clearly applied to both types of private property impounds. And so this is another one of those things that I think we'd like to see a uniform standard, just so that there's no confusion. And it's just, you want to authorize a non-consensual tow, this is the form. If you use it, if you fill it out completely and accurately, you'll never have another authorization issue. Like that's what we're shooting for. So that would be my
So
response.
kind of hitting on that, and basically all of us trying to cover our bases and making sure that our paperwork's always complete. So there's the bottom portion of the tow that says for tow, or the form that says for tow carrier use only. Are you okay with us kind of PDF filling that and making copies of those so that everything's very legible? It's been PDF filled through a computer, and then everything, obviously, like property owner information, they're hand filling that or PDF and signing as they need to. Is that okay?
Yeah, I mean, I think obviously they're going to have to fill out some of this stuff because, again, they're the ones who are essentially giving permission. So like some of this is just stuff that they're going to have to fill out. I don't know that I see a huge issue with making this. And in fact, maybe it's something we'll do on our own, where we make this a PDF fillable for all these different fields. And we essentially provide maybe two copies, or maybe we'll just do a single PDF fillable there. And then if you just want to print off a blank copy, you can. Maybe that's the route we'll go. But yeah, no, I think having this, well, let's put it this way. I don't think it's our intent to, and I don't think that this is actually alluded to in the statute either. I don't know that it's our intent to make this essentially an in-person requirement. Still a way, as long as you're utilizing this form, I think there's still a way you can process some of this authorization paperwork digitally. But it is something that's still going to have to be filled out, at least to a certain extent, by the property owner. So obviously they'll have to provide the signature. They should probably be the one filling out their own information. So the date and the time is like, they're going to have to fill out probably a good portion of what's on this form.
If you're asking about the bottom portion, and then just sending these to our properties and having them available as they need to use them, and then our tow carrier use information is filled out and legible.
Oh, you mean down here at the bottom, this stuff?
Exactly, yes.
Oh, okay, yeah. I personally don't have an issue with that. Like if you want to kind of tailor this form to your specific carrier and kind of have some of these fields pre-filled out for your property owners, I personally don't have an issue with that. It's something that I kind of thought maybe a towing carrier would fill out themselves when they get the completed authorization back, like they fill that out at the end. But I don't really see a huge issue with just filling out at least this portion of it beforehand. I'm not seeing a huge issue with that. Because again, it's something that I think we'd like to see on these completed authorizations anyway. So having it on there when you send it to the property owner for them to complete the authorization and it's already filled out, I don't see that as a like a pre-filled out or a pre-authorized, like a pre-signed form. That's not what it is. It's just, this is straight informational fields to be filled out.
Awesome. Thank you.
Now, along that, on the commercial side, Nate.
Yeah.
It's our understanding that, on commercial properties, we could still have towing agreements and the tow carrier could still authorize on behalf of the commercial property, correct?
Correct.
Now, that being said, just to, make it easy for us and streamline across the board, could our, employees fill this form out on behalf of the commercial properties? And just that way it's, we don't mix up, like we need them on commercial, we need them on residential, but not commercial. We just make it easy for the employees, the drivers. Every single car needs this form. So if you're the one authorizing it on the commercial behalf, you need to fill this form out.
Yeah, so I think that's what we cover here in some of the fine print here. It may be hard to see because it's small print. But basically what we do here in this highlighted section is we describe what a property owner is pursuant to our rule 6501U as in unicorn. So it lists, and admittedly, that definition is pretty broad. There's a lot of people that could potentially qualify and meet that definition of a property owner for the purposes of authorization. So basically, this first part of this fine print here basically is that 6501U definition. Furthermore, in regards to a residential PPI, that's this last portion here, and it just says, please note that state law requires a residential PPI, which is a non-consensual tow from residential property, including from a common parking area, which is the definition under 6501T2, to be authorized by the owner or lessee of the private property, their direct employees, or direct employees of a retained property management company. Now, we haven't gotten that far in our statutory review of the bill yet, but that's the very next section we're going to talk about. And basically, one of the things that it did, and I'll elaborate here when we jump back to the bill, but basically it has essentially cut out third parties for residential PPIs. So essentially, people who have contracted with the private property would no longer be eligible to act as the authorizing agent for a non-consensual tow. It's now specifically only the owner or the lessee of the private property themselves, their direct employees. So if you had a property owner and they employed like a maintenance person, security guard, but they're actually a direct employee of that property owner, that would be okay. Or the only exception they have to that is the direct employees of a retained property management company. So if you have an apartment complex, for example, the owners, have no interest or inclination to be part of the day-to-day operation. So they hire a property manager to act in their stead. Them and their direct employees would also be authorized. That's the only exception, though.
Yep.
So essentially, these third-party companies are essentially cut out of residential PPIs. Now, of course, that's not going to trigger for another week. But that when that triggers, that's essentially there are authorizations that would be okay today that are not going to be okay in a week, if that makes sense. So, but we'll talk about that a little bit more here. But yeah, I think this specific reference to a residential PPI, as well as this portion here, which certifies that if it is a residential PPI, essentially whomever the property owner or whoever meets the definition of a property owner who is authorizing this tow, they're essentially certifying that 24-hour notice was provided. Because again, remember, pursuant to the statute they put in 2 years ago, the towing carrier can provide the notice or the property owner can provide the notice. So we don't think that it's too much of a stretch here to just have them certify that that actually happened. And it kind of keeps them honest. It keeps you all honest too, just making sure that that 24-hour notice was provided. But also note that it says if applicable, because again, there are those exceptions. Yeah, there are those exceptions to the 24-hour notice standard, even for residential PPIs. Or in this case, there's no notice requirement for commercial still. So.
Right. I just wonder if it would scare some of these, management companies when I certify that a 24 hours notice provided. And we got to explain to them like, hey, it's an immediate tow. You don't have to give that notice, but I see where it says if applicable.
If applicable. So, and they can, I mean, we honestly, we want to have the property owners be more involved in this stuff. I mean,
Right.
that's something I've wanted for a long time. They've been away from the table for far too long. And so any little piece that we can do to bring them back, because again, at the end of the day, they are the ones holding all the cards for non-consensual tow situations. Like they are the ones who set the parking policies. They're the ones who decide when a vehicle should be towed or not. They give you, the towing carriers, direction on how to properly service that property. I mean, they're the ones calling all the shots here. And while previous sets of regulations have allowed them to kind of defer that to different parties in the past, that with this new statutory language, I mean, they're essentially getting dragged back to the table. And so I think having stuff in here like this to, again, more involve them in how this works, I mean, I'm hoping it'll help, because I get calls all the time from property owners, and they admittedly don't understand a whole lot about how this is supposed to work. And I like to provide them with as much information as I can, as much as they'll let me, on what the restrictions are and the authority that they themselves have. Sometimes they're even unaware of that. And so, you know, we really like to give them as much information as possible. But, you know, anything I think that we can do to bring the property owners back to the table and really involve them to a greater extent in how their parking situation is managed at their own property, that I'm hoping that'll help.
Right.
So, okay. But anyway, just to wrap up the review of this form, the vehicle information, as I talked about before, the make, model, color, license plate, the state of license plate, and the VIN. For the property owner's information, again, it's all the generic stuff you would probably see on an authorization. So their printed name, their address, their email, their phone number, and then their signature. So, and then basically just these two certifications for the residential PPI, certifying that the 24-hour notice was provided. And again, it's either they're doing that themselves, or they can easily get that from you, and you can just kind of collaborate on making sure that was done appropriately. And then I certify that I meet the definition of a property owner for purposes of tow authorization. So that's essentially, and that's why we included this language down here, so they can see what a property owner is, like who actually can now legally perform these tow authorizations. So I think we hit everything that we need to. Ideally, once we put this in place, we won't really have to change it much. Again, because a lot of it, we've structured it in a way where we shouldn't probably have to modify this too much. Because you know, like you said, we've shared, you know, a draft of this, an early draft of this with some people who have asked for it, just for transparency purposes, just so they can kind of get used to it. But one thing I want to stress here, and I know I stress this in a lot of the trainings that I conduct for not just the towing industry, but for all the industries, you know, check our website periodically. And that's why I'm glad we put this down here, so you can see when the last time we updated the form was. So you can look at what's on our website currently and then double check it against what you're using and be like, yeah, okay, it's still the same copy as what they put in, you know, back in January or July or December or whenever it was last updated. So anyway, but yeah, this is the form. Like I said, our intent is to get this up on the website ASAP. Again, it's not going to be technically required for another week, but once it's required, it's required. And we're going to expect every tow authorization to use this form. So,
Nate, I do have a couple questions. I don't know if you see my hand was up.
Yeah, go ahead, Rob.
A couple things on your form, down in the part there for the property owner. If there's a way where the printed part, you know, you can see where you have more room, if they can make that line a little longer, and the same with the email. When they're filling it out by hand, a lot of times, obviously, handwriting seems to take a little more space than if it was typed.
Yeah, I'll try to expand these fields as much as I can without making it look weird.
And that's all on that situation. And the only other is one of the things, and I don't know, I see that this could be easily adapted to. I can't express for all different types of dispatch services, but like Tow Book, for an example, they're very adept to taking forms like this. They'll put it in, and so it auto populates. And I know you're talking where they're doing electronics anyhow. Would that be a problem if that was in that type of a format, as long as everything stayed the same as what was here?
Yeah, I mean, I think as long as this is the form being, because essentially the statute has directed us, the commission,
Right.
to come up with this form, and that's what this is this is the form we've come up with. And
Right.
again, we wanted it to be as simple as possible, but still hit all the boxes and be
Right.
descriptive and make sure people can understand it without it being too
It-
convoluted and all that. But
Sure.
yeah, I don't know that we would oppose integrating this into a different structure you have, as long as this is the form being used.
And I'll give you an
Um,
example, like the,
okay.
you know, the DR 2008s. When it's done, when it prints out, it looks identical to the state's form. So it's identical to like what you see. It just auto populates with the items already in there. So when you're sending that out, or someone's setting up the tow in, for an example, in tow book, it would auto populate all that. They send it out, and then at that point, you know, it would be as legible as possible at the same time. So.
Yeah, I would say that again, if there's really no way to tell the difference between whatever form you're talking about and ours, I guess I don't see a huge issue. But again, we are kind of structuring this and formatting it in a certain way to accomplish certain things. So I mean, I know there's sometimes where you have a Word document and you convert it to a PDF and it messes up all the formatting.
Right.
So as long as that's not happening,
Right.
I guess I don't see a huge issue with it. But I mean,
Okay.
when we see one of these, we're going to want to recognize it as our form. That's the big thing.
Absolutely. And I will send you some documentation to refer to what I'm talking about at a later time here, but that'd be fine. Thank you.
Yeah, thank you. Okay. All right. I'm going to go ahead and stop sharing this. We'll jump back into the bill. Let's see. We're coming up on an hour. Thanks everybody for your patience as we go through this. Let me go ahead and share. Okay, so we're jumping back in to the statutes. Okay, so we got into this a little bit when we were reviewing the form. And again, that's this new statutory requirement where we have to have created this form and you all have to use the form for authorizations. Like that's what I have highlighted right here. Now, one thing to keep in mind in regards to the authorization, the owners and the leaseholders, or lessees as we call them, of the private property, we allow them to be designated as property owners for the purpose of authorization. Now, there is an exception to this in the statute now, which is anybody who would earn income from the tow cannot authorize the tow. So this is, I think, part of the legislature's bigger policy stance on making sure there's no kickbacks. They had the 40-1051-410 statute in as part of the bill 2 years ago that specifically prohibited kickbacks. I think this is just some additional language that kind of goes along with that. They just want to make sure this isn't any kind of a pay for play scenario. So yeah, just keep that in mind. There's definitely something we want to keep an eye on and make sure that there's no transactional towing, I guess, if you want to call it that. So
right. And they wouldn't muddy the waters with, again, on the commercial properties, we filled out that form. Our employee of the tow carrier authorized that tow. Well, obviously they get paid by the tow carrier. I mean, that's not talking about this in any way, right?
I don't think it is. Again, I think this is more tailored towards the residential side of things. And again, it's the towing carrier authorizing a tow from residential is restricted anyway. So right. I think that kind of quashes that right out of the gate is how I look at it. So, but yeah, for consensual tows, for commercial PPIs, there's no such restriction. It's essentially the same as it was prior to 2 years ago. You can still contract with the private property owner to perform tows and act as their agent for authorization purposes. That's all still in play, like it has been for the last 2 years. Okay. So this is the part that we were talking about when we were discussing the form. So basically, the authorization of a non-consensual tow from residential is limited to the owners and leaseholders. There's some additional language. You can see it jumps from A to B to C here. B talks about people that are part of more communal style properties like HOA organizations and things like that. So, HOA board members, for example, could be appropriate for the purposes of tow authorizations, things like that. So that's what B covers. But basically, this is where it excludes those third parties, like we talked about just a few minutes ago. So you can see previously it said agent, an agent of a person described in subsection A or B could perform a tow, but that's gone now. They've replaced agent with employee. So again, the way we've interpreted that is a direct employee. So basically, you can't be somebody who's contracted with the private property. That's not going to work anymore. So basically, I'll give you an example. So say you have a private property owner and they have hired, and this person is employed by the property owner as a security agent at that property. And you know, they work, maybe it's 3 or 4 people, and they rotate shifts, and there's always somebody at the front desk, you know, that kind of situation. So in that case, the property owner could designate that person because they are a direct employee of the property owner. So that would be okay. I mean, you still have to establish that relationship, and essentially the property owner would still have to defer to that person or designate them in some official capacity to do that. But it's something they would be eligible for. However, if the private property contracts with a security firm to perform services, and you know, they just have a simple contractual relationship, then those security people would not be eligible because they're not employees of the property. So, and again, the one exception to this is right here. So either it's an employee of the property owner or an employee of a property management company retained to collect rent and perform residential services. So I think most property management companies will probably be able to meet that definition, because I'm not aware of a lot of property management companies that don't perform residential services. But anyway, so that's there, and I think most property management companies will probably meet that for the most part. You can always check with them just to be sure, but if that's the case, them and their employees will be eligible. So same thing with the whole security question. If a private property is contracted with a property management company, and that property management company employs security services that they then have offered and arranged to provide at that property, then that they would be eligible too. So again, it's all going to be dependent on how they have it set up, but I think this is mostly straightforward. You know, in certain situations, you might have to kind of navigate it a little bit more than other situations, but I think for the most part, this is pretty clear in my opinion. And again, it has that same restriction on the financial interest. Somebody who has a financial interest or a relationship with a towing carrier or parking lot management company that earns income from the managing or controlling parking. So basically, if they're specifically gaining income based on them designated certain vehicles to be towed, then that wouldn't be okay either. So that kind of mirrors what's up here in this previous section. So anyway, that's it's a big change, and so we're all going to adjust to it. But yeah, I think we'll kind of see, I guess, over these next few months, kind of how this sorts itself out with these third-party companies that occasionally you see at certain properties. So I guess we'll just kind of have to wait and see how this pans out. But yeah, I mean, it seems pretty clear that there's a restriction on this now, and it seems like the legislature really wants to bring these tow authorizations in-house again. All right.
Hey, Nate, now as far as with a lot of, as we have a lot of our members have law enforcement that have them come out, pick up cars, accidents, however, and when the owner's there, they want to call it a private tow. Okay. So then it's consensual when it goes in until they don't pick it up. Then it becomes private property abandoned. Is there that, I mean, obviously that interpretation that's there for another discussion, but at that point, would they be able to, because they're obviously going to be considering it as abandoned, sign in the form, and of course, at some point going to receive some type of monetary payment on that vehicle.
Yeah, I think we'll have to think about that some more. That's kind of a more nuanced situation, I think. So yeah, maybe make a note of that, and maybe we talk about that. I have to think about that one.
Okay, just thought I'd bring it to your attention.
No, that's good. I'm glad we're having this conversation and thinking about some of these potential scenarios. That's good. All right.
Can you clarify for me? Sorry,
Yeah, sure.
this is Midnight Recovery. What if you have like in a place that has assigned parking spaces and it's 2 o'clock in the morning, somebody's parked in somebody's assigned space that they pay monthly for, and they have proof showing that they pay for that?
Yeah, I mean, I think we'd be okay with it because again, it's up here. It says the owner or leaseholder of the private property. So if we're talking about a spot that is specifically belongs to them, I think as far as the PUC is concerned, we'd be okay with them acting as the property owner for authorization purposes. I think the bigger question here, though, is what's the property okay with? And I think that's something you'll want to definitely nail down with the private property. You know, whoever is your primary point of contact there. I think you just want to make sure they're comfortable with whatever arrangement you have with the individual, I guess, tenants or residents. And just make sure you're not, you know, crossing any boundaries or anything like that. But again, our definition and the definition that ended up here in the statute, again, is pretty broad. An owner or a leaseholder, or you know, lesser as we call it, or lessee, that we would be okay with that from the PUC's perspective. But if it's a situation, I mean, you just at least have to consider, what does the private property want? Like, what do they want? Like, do they want to have tighter restrictions on who can authorize tows from that property? Yeah, you may have somebody who's renting a particular parking space, but that in and of itself might not necessarily mean that parking space is no longer under the, you know, the control of the property owner themselves. So I think you just want to make sure you're navigating those situations on a case-by-case basis.
So
I got you.
So you're fine with, like, on our residential towing, we still do our towing agreements just so we know who the people are when they call. But yes, there is, you know, a lot of the multifamily apartments that have reserved spaces that they allow the residents to call in and sign for tows as long as they provide us with proof of their space. And yes, there is certain ones that, you know, all tows have to go through management. So if we have that towing agreement allows the resident to authorize their tow, we could show that in the agreement. We could show the residents proof of their lease or their space, and then they act as the agent and sign.
Yeah, that would probably be the cleanest way to do it, in my opinion. Especially if it's annotated in such a contract. That really clarifies things for us. So if we're working a case and we're looking at a property and we have a copy of that agreement, we have a copy of the tow invoice, we have a copy of the authorization, I mean, we'll be able to connect those dots, I feel like. So yeah, the more this is fully fleshed out in documentation, the better it is, usually, is what I would say.
Okay.
So cool. Yeah, Ms. Senton.
And I would just had a question. I've been kind of jumping in and out because I'm working, so I might have missed something. I was just wondering too, that this is just residential. This is not commercial. Like, we do a lot of Walmarts that do have security for the Walmart parking lot. So we're not talking about, and I'm sure that's a private property that's, you know, hired security, because obviously it's a security company that patrols like the Walmarts and the mall and things like that. So they are okay in a commercial property to call in the tows?
Yeah, so there's a lot less restrictions on commercial properties than there are for residential properties. And again, that's dating back to the bill 2 years ago, where a lot of the restrictions and the new commercial, like the consumer protection style additions and standards and requirements, you know, that was almost exclusively more geared towards the residential PPIs versus the commercial. So, you know, even looking at our rules right now, you can see that there's a lot more heavy restrictions on residential than there is versus commercial. There just is. And again, that's kind of the way they put it in the statute 2 years ago. So I don't know that this bill really deviates too much from that. I think it's still heavy on the residential side versus the commercial. But yeah, it's the way we put it in the rules is that, you know, for a commercial PPI, a towing carrier is still eligible to have a tow agreement consistent with our rule 6508, to have that tow agreement in place, and the property owner is still free to designate the towing carrier as the authorized agent for the property for authorization purposes. There's no restrictions on that. It's just for residential.
Okay, yeah, we have security sign the forms and stuff every time we go out. We have a security agent that called it out, sign all the forms as they act as on behalf of Walmart, but we still have them fill out stuff so we know who called it out, what employee it was, so we're documented, but it is security.
Sure.
Okay. All right. I just wanted to clarify that. Thank you.
No, absolutely. Thank you. So just moving along here, we'll try to speed it up a little bit because I don't want to run over time. I want to definitely get all these questions and I want to cover everything, you know, in the 2 hours we have allotted. I think we're still on track for that, but I may kind of try to move a little more quickly along than we have so far. So this is the last part of this section. So the towing carrier has received permission for each individual tow. So again, that goes back to no batch authorizations, like just do an individual authorization for each tow. That's going to be the best way to do it. And it's not going to conflict with anything. So just make sure you're doing things that way. This next part here, we're moving into, and just so you know, some of the changes that we just finished talking about, those will probably end up somewhere in Rule 6508 since it's authorization related. So again, we'll have a red line of some of these rules that we're adding to essentially integrate these new statutory standards and updated statutory standards into our current rules, just like we did, you know, with the rulemaking that just finished recently. So we'll do it in the same way, and you all will have access to that when it's ready. So you can go in there and kind of get a feel for it. It's not going to be nearly as in depth as this last rulemaking was, because we had to change so much from the bill 2 years ago. We'll have to change a decent amount this time too, but not nearly the same volume. So it shouldn't be as difficult to kind of, I guess, wrap your heads around it as the bill 2 years ago was, or at least that's our hope. And again, we're trying to integrate this new language into our rules in as simplified a way as possible, similar to the way we did it 2 years ago. So just FYI. But moving along here, so this is the standard for the 24-hour notice exceptions under the 4053 statute. So really they only made one change here, and it's just, I guess, eliminating the requirement to display valid authorization. And it just says authorization now. I think one of the reasons they did this is because there are, and we've heard of this, there are certain, I guess, parking permits that are being done, I guess, in a more digital format now, where there's not actual like physical parking passes that you hang around like your review mirror. So I think this is what that was intended to capture, is there may not be an actual physical parking pass that is able to be displayed. It could be just, I think a lot of them are based on plates. So it's like the plate itself and whether it connects to a properly registered authorization or parking permit, that is the check. It's not looking to see if something's in the review mirror. So I think that's what this was about. Also, they changed this to exclusive use of residents or invited guests. So as we all know, there are some certain private properties where it specifically has like assigned guest spaces. So I think that's what that's accounting for. Moving along to signage. So we do have some changes to signage. It's probably not as earth-shattering as you all think, but I'm sure some of you remember the bill 2 years ago essentially took some of the pieces that were in our Rule 6513 and they put it into the new statutes in a couple different areas. There was actually two different separate signage requirements that the bill 2 years ago put in play. One of them was under 4053, and the other one I think was under 4054. But anyway, the way they essentially adjusted this is they removed a lot of these restrictions that kind of, I guess, clarifies essentially what I think we've been kind of operating under anyway. So one of the things it takes out is the like parking by permit only signage, because that was kind of its own independent of the tow signage requirement. So if there was, for example, you have this big lot and like a quarter of it over in this corner is parking permit only, but everything else is open parking. So over there in that corner where it's by parking permit only, there'd have to be an extra layer of signage over there saying, hey, this is for parking permit only. Like, you know, you can't park here unless you have a permit. It was an extra layer of signage that was required if there wanted to be immediate tows for parking in other people's designated spaces or parking without a parking permit. That's what that signage was. They essentially scrapped that for the most part, which means they also scrapped the international towing symbol. I'm sure you all remember that. That's out now, so that's no longer a requirement. essentially what they did is they took some of what was in the, I think it was the 405-4 statute, and they reconsolidated it under the 405-3 statute. I don't know. Something tells me it maybe should have been left in 4, but it's in 3, so we're going to run with that. It doesn't really change a whole lot of requirements, so it's still no less than 2 square feet in size. Has lettering not less than 1 inch in height. That's all from before. Lettering that contrasts sharply in color with the background on which the letters are placed. So no dark green on black background, nothing like that. So this is the part that they changed, was this part here. So it has, basically the signage now has to contain the following information. And it says furthermore, in the order listed below. So that almost makes me think it has to be like in the proper order within how the sign looks. And I would encourage you all to do that. I mean, if some of you are going to be potentially redoing some of your signs anyway, maybe just doing your best to make sure it's in the right order as listed in the statute, because that's just going to be the cleanest way to do it and make sure there's no potential issues. Basically, the big changes here is right here. So as you can see, it still has the authorized parking only language. So that's still there. I know there's been some perspectives on that, but it's still in there. It's still quoted. It's still expected to be on the signage. Now they did shift it a little bit in that language is now only required if whatever restriction of parking applies to that property applies 24 hours a day, 7 days a week. So basically, if you have a parking restriction that applies all the time, then you have to have that authorized parking only signage. Now you can essentially adjust from that and designate these specific times of day and days of the week that a particular restriction is applicable, if that's what the case is. So for example, say you have a parking scenario where the property owners don't really care who parks there during the day, but at night they care a lot. And it's, no overnight parking, 8 p.m. to 8 a.m., residents only. I think that's kind of what it's trying to capture here. So if there are particular parking restrictions that are only applicable during certain times of the day or certain days of the week, that's when you can do that in lieu of the authorized parking only language, is how this reads. So again, it's all going to depend on the property and what they want you to do and what the actual parking restrictions are. And we've seen a lot of different things, but yeah, that's essentially how that's going to work. But I think for the most part, all of you will probably still be using that whole authorized parking only standard. So that's what I would suspect. Still the name and telephone number of the towing carrier. So that's your information. And then this is another new big one. Prior, it was only a requirement that the signs be printed in English, but now Spanish is also a requirement. We've gotten some questions on this, on if this essentially means both the English and Spanish version of the language needs to be consolidated into a single sign. I think our current position on that is having it all on one sign would be fine, but 2 signs, one in English, one in Spanish, immediately adjacent to each other should also be fine. So if that's easier for you, if you already have signs that exist that meet all this other criteria, and you just want to get a Spanish one to slap up right next to it, I think that would probably be okay under the language.
Now, Nate, we have had a lot of discussions about signs, and Lloyd, over the last, I don't know, month, almost 2 months, about this whole English to Spanish thing. This new news and order kind of shocked me, because I've literally just printed a couple thousands of signs with English and Spanish. But is there any way, we've had this discussion, to translate authorized parking only, we could put it into Google Translate and get, one version, then we could ask a Spanish speaking person, got another. I mean, basically we got 4 different interpretations of authorized parking and parking by permit and this and that. Is there any way the commission or the state would tell us what acceptable Spanish, like what lingo or to use?
I mean,
translate word for word. I mean, we've done our best.
Yeah, no, I believe you have. I'd say I'd be a little hesitant to opine on that just yet. I get where you're coming from. I'd hate to commit to something though at this point and then have, all of you and whoever else watches this later be like, oh, okay, this is how I do it. And they go, like you said, print off a bunch of signs and then maybe later we put something in the rule. And again, we may still do that. And if this is something that's going to come up, and in fact, let me make a quick note about this. So almost like what version?
I mean, I guess
of
if you make it a
Spanish
rule, can you
is
go with
okay
the translation
for
that we came up with?
Spanish? Yeah, I actually I've seen it, but I haven't had a chance to really look that deeply on it yet. But yeah, I mean, I get where you're coming from, that there could be multiple Spanish translations for some of the what is required language on this signage, at least from an English standpoint. So,
And Nate, let me point something out.
Yeah.
Because Stephen's right. He did call me. We had this discussion. My recommendation to him at the time was to reach out to a local university Spanish instructor who could give us some broad interpretation of this in a dialect that's unique to this geographical area. And
Yeah, we did. Yeah, we did reach out to a Spanish speaker and she sent us our interpretation or her interpretation, this and that, and kind of gave us some scenarios. And that's what we ended up with on the sign. I think Jacob might have sent you the proofs, and that's what we ended up printing.
Yeah, and that's what I was waiting, and Jacob did send that to me, and I'll get back with you on that, Stephen. We were waiting for this meeting, but this is definitely an issue, and Nate and I can talk offline about it and figure out how we want to approach that.
All right. Yeah, we've been already trying to get signs up night and day with this English and Spanish. So hopefully it works.
Yeah, I've made a note, Mr. Carnes, about that, and we'll go ahead and add that to our discussions when we're drafting the rulemaking. It may be something where, even though there may not be something about that on the initial red line of the amended rules, it may be something that the commissioners specifically asked to be commented upon during the rulemaking. In which case, maybe something more official would end up in the rules somewhere where it's like, oh, your Spanish version has to say at least this and this. And again, we have our own Spanish translators in-house at the PUC that we can potentially use for that. But I'd rather circle on the commissioners on that before giving any kind of a official or even unofficial position. And I know you all are struggling because you got to have something pursuant to the statute. I guess for now I'd say do the best that you can, and obviously we'll take your good faith efforts into consideration with that for sure.
Well, I got an issue with that, Nate.
Yeah, go ahead, John.
Well, it's not the tower's responsibility on the signs anymore. That's the property owner's problem. Property owners are the ones responsible for the signs. So I think we should probably invite them to the table on what the signs should say or how they're written. It's not that was the fight we had at legislation is we're the tow carrier. It's their signs, it's their property. So I think there needs to be a little leeway given to the tower if the signs aren't perfect, because it's not the tower's responsibility. So I think going after the tower because a sign's mismarked, I think is a stretch. And I would have huge arguments with that one.
Yeah, no, and I think you make a good point, John, because actually I didn't mention that earlier, but you're right. If you look here under this new section for signage, under 4053C, it says in order for a towing carrier to conduct a non-consensual tow, the property owner must have posted signage. You're correct. I think initially there was discussion on making it either or, like a property owner or a towing carrier has to.
No, initially, let's just cut to the tax of it. I mean, the brass tacks was initially stick it in the tower's ass. All right. And I fought for that to get it out of the tower's ass and let the property owner deal with their own signage. Mm-hmm. So I don't want to see where towers are taking a hit for signage when it's not our responsibility anymore. And here again, I'm a redneck American, okay? I don't speak a Spanish. I don't read a Spanish. So if I see a sign that says something in Spanish, how the hell do I know what the hell it says? And I'm too old to use the Google or Translate or whatever the hell it is to figure out what the hell it says. So I think a lot of that needs to be put on the property owners. I think that should also be in that authorization. When you guys are doing that authorization form, you can put on there that the property owner guarantees that their property is properly posted, etc. And it needs to be put back on the property owner. I get tired of fighting for the towers when it's not our world there. And I think we need to look at that.
Okay. Yeah, no, and like I said, I think you brought up a good point about, the fact that the statute does say the property owner has to have that posted signage. Keep in mind though, there are things in the statute that reference a property owner doing certain things, but the commission has no authority over a property owner doing or not doing something. We have no jurisdiction over the property owners and what they're doing or they're not doing. We just don't. And so, but we do have full authority over towing carriers and what they're doing or not doing. So there is that relationship where at times it is going to be a towing carrier's responsibility to recognize when certain criteria or certain requirements are not being met when they're being asked to perform a certain tow, and recognize that. And you can always refer the property owners to us. I've had that happen, and I'll set the property owner straight on what the towing carrier can and can't do pursuant to law. But I do think some of that responsibility, at least to a certain extent, does extend to the towing carrier, just because, again, they have to be aware of what these requirements in the statutes are, even if it's something the property owner is supposed to be doing. Because if certain criteria has not met, the tow may not be able to be performed. And again, you can always circle with us and check with us on that, and we can try to help you navigate some of this stuff. But I talk to property owners all the time, and I try to educate them on this stuff because, like I said earlier, a lot of times they are completely unaware of some of this stuff, and so they need your help, the towing carrier, who is a little more steeped in this regulatory environment, to let them know essentially what they can tell you to do or not do. So, because you could have somebody come up to you tomorrow at one of your properties and say, "Oh, that guy's vehicle registration's expired and it's on a residential property. But the plates are expired and I want you to tow it." Well, how should you respond to that? Well, the way you should respond to that is say, "I can't tow it for that reason because it's against the law. It's under, whatever it is, 40-10.1407 or 8. I forget which statute it is. But it's not legal. You can't do it." And they need to, if they're not aware of that on their own, someone needs to make them aware of it. You all deal with it a lot more, or deal with them directly a lot more than we do. And while we're happy to tell them, if they're just not buying what you're selling, we're happy to do that. And I do it all the time. But I guess that would be my comment on that is,
right.
These
and
statutes,
I'm not opposed to what you're saying there, Nate, but what I'm saying is it's not the tower's responsibility to build the signs and post the signs. It's the property owners. So when we're having these discussions, and I hear towers all the time, well, what am I supposed to do? And how do I make these signs? It's not the tower's responsibility to make the signs. It's the property owner's responsibility. And we need to get that driven home. Yes, it's okay for the tower to understand the rules, but why are we trying to explain to the tower how to build a sign? Do you see my point?
Well, I see it, but I also see I see in the statute saying, if you're going to be conducting non-consensual tows in this property, this signage has to be there. So as the tower, you have to recognize if it's there or not. Even if you're not the one posting it, you have to be aware of if it meets the criteria or not. Because otherwise, that next conversation should be with the property owner saying, "Hey, you got sign, or you have no signage, and therefore I can't perform the tows you want me to perform, or the signage you have doesn't meet all the required criteria." It doesn't
right.
have
It'd be along the same lines, as not towing for expired license plates, etc. It's along those lines.
But again, it's kind of a sticky situation because, again, while these statutes are specifically telling a property owner they are responsible for doing a certain thing, and it's not just here with signage, there's other parts of the statutes that do this too. But we have no enforcement capabilities over the property owners. Really, at best, the only thing we can do is essentially tell them, if you don't do X, people shouldn't, towing carriers should not be towing for you because it doesn't meet the criteria. That's essentially the best we can do.
Sure.
And that's frustrating because, if things are in our statute, we want to have an ability to enforce what we have. But again, given our very limited scope of authority as granted by the legislature, we just don't have any authority over property owners.
Sure. But you also have that form that you make them authorize, right? And under that form, that authorization form that you have them sign, couldn't you add something that said they abide by the rules?
So here's how I would respond to that is, we're not going to the property owners with that form and saying, you have to fill this out. That's not what we're doing. We're coming to you, the towing industry, the people we actually have regulatory authority over, and saying, if this form isn't filled out, you can't tow the vehicle. That's essentially, so that's the difference, is we're not going to the property owner. As much as I want to involve the property owners in this, that only goes so far, because if they're not doing something they're supposed to, really, there's not admittedly a whole lot of recourse for us at the PUC. We can't hold them to that standard.
Well, and I get where you're coming, Nate, I get where you're coming from on the PUC. Okay. But I got to look at the tower. You got to look at it from my shoes. Okay. Sure. How does the tower protect themselves? Right. So you have to have this form that gives the authorization. Why can't you on the bottom of that form where it says, I abide by it, et cetera, you have that little paragraph in there. I don't have it up in front of me yet to word for word it, but why couldn't you put in there that the signage must be, like the law says, posted like law says, and that the person authorizing that tow is granting that, saying, yes, we're saying yes, that it is legal, right? Then when the shitstorm happens and you're going after the tower has something to go back on to that property owner and say, look, you signed it here. Okay, you're saying that it's legit. It's not legit. How do you save the tower's butt? That's the kicker. And I'm just trying to get to the point where I'm tired of seeing the tower take it up the ass constantly.
Right. I appreciate that, John. And one thought I've had on our side here is, now that things have changed, is telling the properties like, yeah, we have to have this signage, and how many signs do you need? They're this much, and we'll drop them off, and you need maintenance to hang them up. Our only hang up on that has been, one is, are they gonna, put them where they're supposed to? And, we take pictures of every sign we hang and put it in our system. So it's like, will they put them up in time? Will they send us photos? But yes, we've been thinking about doing different ways, John, of like, how do we, put it back, just as a company, just tell them, hey, you got to pay for these signs. You got to install them at the entrances, at these places.
Sure. Yeah, no, and I hear both of you, and I definitely understand where you're coming from. I think
huge costs on us.
Well, no, I understand, and it always has been. But yeah, I get what you're saying now. And again, this clarification within the statute that the property owner is responsible for the signage, which again is pretty intently put in there, is my understanding. I mean, the property owners are going to have to, if they want this to work, they're going to have to step up and do their part of it. It's just,
there's another way you could look at that, turn around into part of the phase of, if one wants to call the fine stage, that if it's over just a signage situation, that the tower isn't responsible for a free tow, completely refunding the tow. I mean, there's, the point being is, that's the whole problem right now. I think the biggest thing is all the financial responsibility is put on the tower. Yeah. And that is one of the reasons it was agreed to put some of that back on the property owner when the statute was being written.
Well, and that goes back to my original point of, the towing carrier has to recognize when some criteria is not being met, even if it's not necessarily their responsibility to meet that criteria. So, and again, we're looking at it at the PUC, we're looking at it through the lens of, is a towing carrier performing a tow where a certain criteria wasn't being met. That's kind of, I think, more how we're looking at it. And so I get how that sounds, and I can feel, you know, how you guys are seeing this. I guess, you know, to John's question, like, what do we do, you know, to protect ourselves? And I think the best thing is always to do the best good faith effort that you can in these different areas. And when it comes to signage, you know, having those conversations with the property owners and being like, this sign has to meet at least, you know, XYZ criteria, all the stuff that's listed here that we've been talking about. And it has to meet this, or else, you know, I'm putting myself in a compromising situation if I tow when when the signage criteria has not been met. So again, this is, I think, part of that bigger piece of bringing, you know, the property owners back to the table, because they've been essentially sitting on the sidelines for a long time on some of this stuff, and they should be more involved. That's something I've been arguing for years. So anyway, is this all perfect? No, but I think we're trying to do the best we can. And again, we'll adjust our rules in a way that hopefully makes this easier on all of you. But again, we are pretty stuck to what these statutes say in some cases. And so if it says you can't conduct a non-consensual tow from a residential private property unless it has all the appropriate signage that meets all the criteria, then that's the kind of stuff we're going to check if somebody files a complaint with us. And either it meets the criteria or it doesn't.
Hey, Nate.
So yeah, go ahead.
I hear what you're saying and saying, hey, we need to just make sure that we are aware of the requirement because we should just as much cover our butts. I hear you there. However, to be a property manager, you do have to have or be a real estate broker. So that is a regulated license that they hold. So, I mean, just a thought would be maybe we liaison over and we say, hey, we really need to have some powwows with you guys and help you guys understand what's required of everybody now.
Yeah. Okay. All right. Ms. Henson, your hands have been up for a while. You want to jump in?
Yeah, I was just wondering, what's the timeline for these private properties to post these signage in Spanish? Like, how long do they have? Do we have a certain date they have to be posted? Are they giving us any leeway for these guys to get the signs up? We have a ton of contracts, and so I mean, we're letting them know as soon as we can. But to call like 300 contracts and let them know, we have not done that. So there's not really a way that the private properties know to do this. So we're telling them one by one. So is there like a certain leeway time that these properties have to post these in English and Spanish before deadline or something? Or is it just like right now, this is what it needs to be?
Yeah, I mean, again, these statutes trigger in a week.
Right.
So basically everything we're going over right now, everything that's going to become state law on August 7th, that's when it goes into effect. And so again, I think the expectation is that this stuff would be met in a week. And I'm glad we're doing this at least a little bit ahead of time, you know, to kind of gain that traction and kind of have people, you know, be aware.
How do the private properties know? Like, is there a way that the PUC or that these property management companies have these meetings with you or with whoever of their regulatory services, like that they know that these laws are in effect? Because I speak to a lot of them daily and they don't have any clue of what laws are what, and they don't really know where to get information. So is there places that they are supposed to be looking out for these laws?
Yeah, well, yeah, and I think to a certain extent, you know, certain associations and such were involved in the legislation, so they should be aware of this stuff, and they should be disseminating some of this information. I mean, we can do what we can to try to get the word out to these carriers about these new requirements. You know, in the past, we've worked with, you know, one of our other internal divisions here at the department, the Division of Real Estate, to try to have these kind of conversations about towing with, you know, these larger groups of HOA associations and other types of property owners and stuff like that, and managers and all that. So, I mean, we're happy to do that kind of stuff. I mean, that's one of the reasons we're we're holding this meeting now is to kind of explain to you all what's expected. If you want to relay that to them, that's fine. If you want to refer them to us, that's also fine. I think, I mean, there's a ton of property owners out there. So there's no like listserv that includes all of them. Like I wish there was, but since there's not, I think we're kind of putting that information out there as best we can. And definitely appreciate your all's help with that, because some of this stuff is new and it does impact potentially ways they have been accustomed to towing working at their properties, and they need to be aware of it, just like the bill 2 years ago shifted things up too. And I had property owners calling me all day saying, hey, what's this new requirement? And I explained it to them. So, but yeah, I mean, we do what we can to get the outreach out there, and get people to but yeah, we don't regulate them, and so we try to help wherever we can, however we can. But yeah, definitely need help with that, because I know you all have a lot more face time with them and you know who they are than we do. But we try to help where we can.
Thank you.
Thank you. All right, we'll go ahead and keep moving. Okay, so we talked about all this signage stuff. A lot of this other stuff here that we were coming up on isn't really that different from what was in place before. It's about posting in certain places, making sure it's permanently mounted. Signs have to face outwards towards the street, not internally. I think this is, I don't know if this is a new one or not, but they're inside the private property. I know the PUC's kind of major stance has been more about posting signage at the entrances, but it looks like there may be some internal posting requirements as well. And I know a lot of you do that anyway. But anyway, that's something we may need to adjust in Rule 6513 potentially. Yeah, not being obstructed, so don't post it, or don't make sure it's not posted behind like a plant or a tree or something where nobody can see it. Not placed higher than 10 feet, lower than 3 feet. Again, a lot of this stuff has been a rule for a while. Here's the other part of that form, the authorization form that we talked about earlier. Requirement for retention of that form, the authorization form, is 3 years. I think that's consistent with what we had in our retention records standards anyway. So I don't think there's much change there. So this is a new one. Towing carriers not patrolling or monitoring on behalf of the private property owner. So it's basically it's just what it sounds like. It's no longer allowed. It's pretty straightforward. I think that will only apply to residential PPIs. That's one of those standards that I think is more geared towards that anyway. I don't know if we're going to need to adjust any of our rules to, well, we'll need to put it somewhere. I don't know that we're entirely sure where we're going to put that one yet, but we're working on that. Okay, so 4054, storage facility signage. So it adjusts the language here on some of the language that's required to be at tow facilities that store vehicles that were towed as residential. It basically adjusts all the terminology to, instead of it saying owner, it's authorized or interested person. That's kind of the catch-all term of people who could have an interest in the vehicle. So it just adjusts that to kind of, make the language a little more consistent. Let's see. Oh, and this part right here, this is all the stuff they crossed out and moved to the stuff we already went over for signage. So this was what they had in the statute before, but as you can see, they crossed it all out. So that all got moved into the different section that we already talked about. Mechanic lien. So this is the recovery of personal property, where an authorized or interested person can essentially come and collect personal property. This just, I guess, clarifies, the legislature wanted the people, like the authorized or interested person, to be able to collect the contents themselves. Because I think prior to this, it was, I think, an option for either the towing carrier to do it or the person to do it. It looks like they crossed that out. So I'm guessing their policy stance is they want the person to be able to do it. So whoever the appropriate person is to go in and collect the belongings. I'm guessing that probably will require a change to Rule 6512D, most likely, is probably where we'll make an adjustment. The other part, so these two parts here, it's actually kind of this next half a page or so. So all this stuff here, yeah.
Real quick, going back on that retrieving vehicle belongings, you know,
Mhm.
if you're gonna make it in commission rule or whatever, or change it or tweak it, it's fine for people to come get their crap out of their car. I mean,
Sure.
is there a way to, after it's been there 24 hours and before the 30 days is up, like to have it like, hey, you need to do this during business hours. So we don't, have the tweakers showing up at 2 a.m. and want to just unload their whole freaking car. And you got to have somebody on shift and out there. And maybe you don't want to be in the yard at 2 o'clock in the morning with these people.
Sure. I think all the regular standards for vehicle release, I think would still apply to this. So I think what you can use kind of as guidance for that kind of a situation is look at it's 65. Hold on, let me find it here.
Just for instance, like, the big vans or something we towed, we've had it for 2 weeks and yeah, all of a sudden they want to show up at midnight and,
So
spend
yeah,
unloading this. It's like we'd
yeah.
like
So I would look at 6512B. So that basically is the release standard. And it's a towing carrier that accepts for storage a motor vehicle that has been towed as a non-consensual or law enforcement order tow shall provide access to or release of the motor vehicle to an authorized or interested person, either with 1 hour's notice during all times other than the towing carrier's business hours that occur within the first 24 hours, or upon demand during a carrier's business hours. So if you tow a vehicle and somebody then calls you, 72 hours later and they want to come at 2 a.m., I think it looks like under this standard, you would be within your rights to tell them, no, you got to come
you come during
like,
business.
like the following day during business hours. Even in a scenario where it was after hours within the first 24, and therefore you're obligated to let them essentially have access to the vehicle or get it released, then at that point, I think you can defer down here to 65. Hold on, what is it? 6512E. And you can still essentially potentially not comply with 6512A through D, and that was under B. And I think it was, I think it's this one here. So B, what is that? E5. So it says the towing carrier, upon notification of release of or access to a motor vehicle at other than the carrier's business hours, has immediately contacted appropriate law enforcement agency in the interest of public order, has requested officer presence. So you can still do that too. Like if you're within that first 24 hours and it's like, I technically have to let this guy, poke around in the vehicle, technically, you could still incorporate that exemption and essentially request law enforcement be present when they're there, especially if you think they're like under the influence of drugs or alcohol or whatever.
Right.
So yeah, so you have some options. I think
That works.
Cool. All right. So anyway, again, just some language tweaks here for authorized or interested person versus owner. That I think is how the legislature meant to put it in 2 years ago anyway. And then the form for the release without full payment standard for residential PPIs, they said the department shall create the form, but it's the commission. That's us. I mean, we're the ones who did it anyway. And then this is just, I think, a clarification of what we saw in the public comment hearings for the last rulemaking on that standard. Basically, they're just clarifying that a towing carrier can't require any additional conditions for release other than, again, it has to be an appropriate person. They have to be willing to pay that lesser fee. So, 15%, $60, whichever is less, and fill out that form that we created pursuant to the statute. So those are really the only three things that you can use as a condition for release. No additional criteria can be imposed as a condition of releasing the vehicle under that standard. So, and I think this is just them clarifying it. We kind of clarified it in rule anyway under 6512L, but I guess they wanted to put it in the statute too. So there it is. I actually don't even think we'll need to make any rule adjustments. We might need to tweak 6512L a little, but not as much as we would have had we not put it in rule the way we did. Towing carrier responsibility. This was something we had them move out of the 405 statute, which again is more geared towards residential PPIs. Really, it's a towing carrier's responsibility to secure, basically ensure the security and safety of the vehicle while it's in their custody. And that goes for any type of tow. And so they actually moved it out of 405 and put it into the new 411 statute. So now it applies to all types of tows. So I think that's kind of how we were probably going to treat it anyway, because that's a very important consumer protection that was clearly not the intent of the legislator to rip out for everybody but residential PPIs. So that this is just them clarifying that. Applicability section for the 405 statute. I don't know that what they changed here. They just crossed one line out of like a 6 or 7 line section. I don't know that it really changed a whole lot. I still think we have the residential commercial split the way we did before. Really, the only way I can think of that this changes things is it kind of eliminates a potential scenario where you might have something that can be identified to meet the definition of a common parking area for use with residential parking, but it actually technically being on a commercial property. But I don't know that happens a lot. So I don't know if that was their intent to remove that for that reason. But I mean, at the end of the day, when you read this, even as modified, I don't think it changes anything. It's still, at first glance, for the majority of PPIs, you're going to be able to just glance at it and know if it's commercial or residential. For the vast majority of tows, it's clearly going to be one or the other. Now, we have experienced situations where you have like a multi-use situation, and our team is good at tracking those down and doing the research and figuring out what it actually is or what it was when the vehicle was towed and therefore which standards applied. But we're good at sorting that out. But even that, I think, has only happened a handful of times in the last 2 years anyway. So I think for the most part, we can essentially treat this mostly the same as we did before, where, again, when we're talking about PPIs, you know, in almost all of them, it's going to be clearly one or the other. There's not a lot where there's overlap. So I think we can just continue with that. Failure to comply. So this is that new 48-hour standard for return of vehicles. So this is something they put in that kind of, in a certain way, mirrors what we already kind of have in place for 6511F. It was originally 6511I, and then it became 6511G, and now it's 6511F. But it's basically our towing carrier can't keep fees if there's violations standard. And that's been on the books for, I think, as long as I've been at the commission, over a decade. And basically, it all boils down to if there's an issue with the tow, if there was a rule that was violated, a statute that was violated, as a result of the tow, then you can't keep any proceeds from the tow. That's essentially what it is. And again, that's been on the books for many, many years. Essentially what this does is something similar, where a vehicle that has been determined to have been performed in violation of either the statutes or some of our commission rules that apply to the situation shall be returned back to the location from where it was towed within 48 hours, unless one of two things. One, either the authorized or interested person just acknowledges they want to just come get the vehicle, like that's easier for them to do that, or quicker for them to do that. That obviously is a exemption to this standard. And then also, if returning the vehicle to the location from where it was towed is not practical. So for example, say you have a vehicle that's been abandoned on a property for 6 months, and you tow it, but then there's some issue, and so you can't collect any money. Well, obviously, you're not going to take it back there because it shouldn't have been there in the first place. So it is, as you can see here, as determined by the commission, what is practical and not practical. So, I mean, maybe we'll put something in the rule about that, about what's practical and not practical, but I'm guessing we might just leave it open-ended and just handle it on a case-by-case basis. Because again, we see a variety of bizarre scenarios within the towing industry, as you all know. So we just try to navigate those as best we can. All right, moving on. So this is an expansion of the deceptive trade practice standard. This is something they added as part of House Bill 22-1314 2 years ago, where they essentially changed the definition within the statutes that allowed the Attorney General's office to consider certain towing practices to be quote unquote deceptive trade practices. Now it's not anything that we deal with directly. We still work essentially the same standards as we always do, but it essentially gives the AG's office latitude to potentially pursue the towing carrier through a different lens, more or less. This expanded that to include the any relevant district attorney's office to do the same. So basically, it's not just limited to the AG's office anymore. Now DAs can do it as well. So, and then moving on, here's that move that I mentioned earlier about tow carrier responsibility. It's mostly the same language as before, but they just, again, recategorized it. They took it out of the 405 statute, which kind of had the implication that it only applied to residential PPIs, and they moved it to 411, which applies now to all towing carriers and all towing types. So basically, if you've towed a vehicle, it's your responsibility until it's released. That's essentially what it means. And again, this is just an expansion of that deceptive trade practices. It's just they had to make a change to Title VI as well, because that's where that language resides. So again, a towing carrier that conducts a non-consensual tow in violation could theoretically be considered that. The sunset review. So we actually were in the middle of the towing industry sunset review starting back in December, and we worked on it for a good 6 months. But as part of this bill, they shifted it. It was supposed to be due next year, that sunset review, but now they bumped it back 5 years to 2030. So essentially, we'll just pick up and do it again in 5 years. I think they wanted to see, how the changes they made 2 years ago and these changes actually, I think they're just waiting to see what the impacts actually are. I think that's why they moved it. And then this is more on that. So again, just a shift of the dates for the sunset review. So 40-10.116, commission to notify local authorities. So they added some language here just regarding, basically what it means is people don't necessarily have to exhaust all potential remedies through the PUC before they pursue a particular action elsewhere. So for an example, if a towing carrier, or if a vehicle or a person whose vehicle was towed wanted to pursue you in civil court before they even filed a complaint here at the PUC, they technically could do that. I think that's not how people tend to do stuff. I think they tend to try to pursue things through the PUC first before going to other external potential remedies. But anyway, this just clarifies that a person has the right to do that. Like they don't necessarily have to do everything they possibly theoretically could through the PUC before they do other things outside of the PUC. Okay, I think that's about it. And again, due to this act subject to petition clause, like I said, these statutes will become effective next Wednesday, August 7th. All right, I think that's all I had for today. We're butting up right against the 2-hour mark. I definitely appreciate everybody's patience. People who have come here for the whole presentation. I'm going to go ahead and stop sharing that for now. Do we have any questions to follow up with? Anything we talked about or didn't talk about? Like I said, we're going to be using these statutes to essentially incorporate new language into our current rules, which again, this most recent version of rules has been effective since April 30th. But yeah, we're looking to introduce this next rulemaking as soon as possible after the statutes trigger. Because again, there is that statutory deadline that whatever rules we come up with have to be in place by September 1st of next year. So as I'm sure a lot of you remember, the last rulemaking we did took over a year. So I think we want to get this one moving as soon as possible. I don't think this next one will take us a year. But I mean, just depending on how things shake up, it could take up to a year. And so we're butting up against that deadline. So we just want to make sure we're aware of that so that we're not breaching the statutory deadline.
Hey, Nate, I got a question.
Yeah, go ahead.
Is it going to be on the NOPR? Would it be easier if the association opened it or asked to be opened?
I mean, you can if you want. I mean, we're gonna open it, and I would. It may be more expedient to wait for the NOPR decision to come out, which again, we're talking it's weeks away. I mean, it's coming. And so it may be more expedient to see what that initial draft we're putting out looks like first. So like look at the red line, look at the decision, see where we're going with it. And then as the association, if you want to then respond to it like you have in previous rulemakings through a written comment or also participating in the public comment hearing. That might be quicker. I mean, unless there's something specific you want to include, but I mean, the way a version of rules goes in its initial draft often isn't what it is coming out the back. And so
Well,
we can always add new stuff. If there's stuff you think we're not addressing, you can raise that and we can consider that to potentially.
Well, that was the question, is because last time we did that, we tried to add some things and we were told, oh, that's not the scope of the NOPR.
Okay.
So I want to make sure the scope of it is everything. that there's no there's no bush we can't unravel.
Sure. Yeah, no, I think it probably will be more geared towards the legislative implementation, just because that, I mean, again, this is all the reason we're moving so quickly with it is because there's a statutory deadline. So I think that will be kind of the focus of it. But I mean, there's other things like in the red line draft, there's other things outside of the legislation that we're changing. So
Okay.
I think that opens the door a bit for other stuff too.
Okay.
So was there anything specific you were thinking?
It's too late to go into that. Yeah.
Okay. Well, yeah, I mean, if you want to just shoot me an email, we can talk about it more.
Yep. I'm sure we'll talk many times before then.
Okay. Sounds
All
good.
right.
Rob?
Yeah, actually, one of my questions was what you were kind of referring to. So do you have a red line version drafted at this point already, or no?
In the process.
Okay.
I'm not quite as far along as I would have liked to have been. I actually was hoping to have it done by today, but I'm hoping to have it done by the end of the week if I can.
Okay. When it gets to that point, would you mind sharing that, or does that have to come out on, what do we need to do to be able to take a look at that?
I'm not 100% on that. I'm not sure if it can only be publicly available through the actual filing in the NOPR, or if there's some flexibility there. I'll check on that for you though.
Thank you very much. Last but not least, involving, to kind of go back and hit one spot about the verbiage situation with the Spanish on the signs.
Mm-hmm.
Is there a version of Spanish that could be referred to as, so that I understand it's not having you specifically say word by word what the sign says, but it says what dialect it needs to be? Is that a possibility or no?
Like I said, I think we can certainly explore that. I'm writing down like some of the bigger points we've talked about, in some of our sidebars as we've been going through this. I've been writing notes on them. So I think probably what we may want to explore doing is, when we have a red line drafted, even though it may not include some of these items, it's something we will definitely raise with the commissioners when we meet with them on these issues. And we'll throw out here, the industry feels strongly about this, and they feel strongly about that. Because that's important context for them to have, because that can result in them specifically calling out certain issues to be commented upon. And so even though the initial red line draft might not have a reference to the dialect like you're requesting, it may include a paragraph saying, we as the commission encourage towing industry and anyone else to specifically comment on whether or not we need to include specific references to dialect for the Spanish translation for the signage requirements, for example.
And if you could put the good word in that, maybe Elite Towing made a good example, and the one we sent to Lloyd, alleviate a lot of problems on my end.
Sure.
Hey, I like that idea. Yeah, I'm all about that.
Sure.
Nate, I texted you, Nate, those pictures. You have those.
Yeah, I saw them. I haven't had time to actually like look at them and compare them to the statutes and kind of see how they look.
Right.
Yeah.
Stephen, we will get back to you on that.
Perfect.
I think the biggest thing is, I think why that is such a very important part of that is, obviously, as you can see, the people attend today, there's a lot of people trying to do it the right way, but there's nothing worse. I mean, money's tight enough as it is, but to turn around, Steve's point exactly. You print up X amount and then you throw those away and go back and do something else in 2 months or 3 months.
Well, I spent thousands of dollars on signs last year to do this tow symbol, and then those are all useless. And I've literally been trying to get the Spanish thing, and I've just ordered 2,000 signs, and basically we've had guys day and night putting signs up. And so if it changes, this is going to be a big problem for me.
Well, and just Mr. Carnes, just to be clear, if you still have signs with that international tow symbol, there's nothing that says you can't have that on there.
Right.
It's just not a requirement anymore.
Right.
So, I mean, if you have signage that can still meet the criteria as under the new structure of the new statutes, that would still be okay.
Right.
So,
That's what I'm hoping for. So I'm hoping
right.
for my example of the Spanish translation fits the criteria.
So Steve,
Yeah.
Steve, you can still have your pretty tow truck.
Yeah. Well, the tows are not coming in and the costs are going up. So
Well, and we're
Signs are gonna
cognizant.
be fine.
Yeah, we're cognizant of the fact that, we're going, as of now, we're just going off of what the statutes say. And do the statutes contemplate every particular scenario? No, they don't. It's more high level stuff. And so that's why we do these rulemakings, is to really burrow down into some of these issues and try to sort them out in a way that doesn't conflict with the statute, but maybe expands in a way that is not contradictory to the statute, but also gives some additional direction and guidance to all of you, so everybody can understand what is expected. So I think, while we're similar to what we did 2 years ago with that last bill, we're definitely going to be considering, those good faith efforts and recognizing what the statute says and meeting that, but at the same time recognizing that there's some gaps that we need to fill through the rulemaking. So we take all that into consideration when we're in this limbo period, so to speak.
Thank you very much, Nate.
Thank you, Rob. And thanks everybody for being here. I really appreciate it. 2 hours is not an easy thing to sit through and talking about some of these heavy issues. So I definitely appreciate everybody's time. Like I said, we have recorded this, and so we should be posting this up on the towing website. We'll probably put it on the towing carrier specific part of our webpage. So you can look for it there, or, feel free, the TRPC folks that are here, if you want to share it with your group, that probably would be helpful for anybody who wasn't here today for this, who wasn't watching it streaming. But again, we thank everybody for being here. Like I said, we'll try to include everybody as much as we can in the upcoming rulemaking. We encourage everybody to participate once it gets moving. Please file written comments. Please attend the public comment hearings and share your thoughts on some of this stuff. Like I said, I don't think this rulemaking will be quite as intensive as the last one was, because there was so much we had to change last time. But there's still plenty here we got to change, just to make sure we fully incorporate these new legal standards into our rules. But we're gonna work with you as best we can to accomplish that, and we'll do our best to work with you as these new statutes become effective. I know Lloyd and his team will commit to that. Feel free to give us a call anytime. Shoot us an email. Just give us a phone call. We're happy to talk about this stuff. There's always little nuanced situations. We recognize that. We're happy to try to help you sort through it to the greatest extent that we can. We don't always know all the answers, but we usually know quite a few. So definitely appreciate and take the time to help you with that. If something comes up, please let us know.
Perfect.
Nate, you're awesome. Thank you.
All right. Thank you all. Have a good rest of your day. Yeah, we'll be in touch soon. Thank you, everybody.